SJC 11718, Commonwealth v. Jamie Caetano.
Good morning, Mr. Keene.
Good morning, Your Honor. May it please the Court, Benjamin Keene on behalf of Jamie Caetano. This is an appeal from Ms. Caetano's conviction after a jury-waived trial in Framingham District Court for possession of a stun gun in violation of Chapter 140, Section 131J. The Court granted direct appellate review and solicited amicus briefs pertaining to the Second Amendment questions raised by the defendant's conviction under this statute, including the circumstance, as noted in one of the amicus questions, that the defendant was homeless. Before I address the merits of this important Second Amendment question, I would like to respond briefly to the Commonwealth's argument that this conviction is not reviewable by this Court because, according to the Commonwealth, there was no appealable judgment below. I have addressed this in a reply brief that I was unable to get to the Court in a timely fashion, but it has been filed.
You got it. No, we've seen it.
Well, if I can just underscore a couple of points on this question, the record makes perfectly clear that at the sentencing, after the judge found Ms. Caetano guilty, the defense counsel consented to the prosecutor's request that the conviction be placed on file. He also clearly objected to the prosecutor's motion that the stun gun be forfeited. Sometime later, defense counsel became aware that it was possible that by consenting to the prosecutor's request that the case be placed, that the guilty be placed on file, that might be construed as some impediment to appellate review, and he thereafter filed a motion to either impose sentence or to lodge an objection to the guilty filed disposition. The judge, after a hearing and with the cooperation of the prosecutor below, elected to accept the defense counsel's objection to the placing of the guilty conviction on file, and rejected the alternative that was proposed, that she fine the defendant. So the Commonwealth argues that this was somehow improper. I failed to see how it is improper for defense counsel, for the parties, to try to perfect the defendant's right to appeal. And moreover,
when was the defendant was convicted on July 10th, 2013?
That's correct. And
was the appeal brought timely thereafter?
The notice of appeal was filed in a timely fashion.
When was that? About
5 days later.
Okay.
And the motion to impose sentence was.
I have a. It says on October 1st, 2013. 3 months later, the defendant filed a notice of appeal.
Following the lodging of the objection, and I was at this point monitoring the case, I filed a second notice of appeal.
All right.
To remove any possible procedural question as to the defendant's efforts to perfect her right to appeal.
If we can turn you to the stun guns.
Thank you.
It seems, are you transforming the Second Amendment right to bear arms into a Second Amendment right of self-defense, of generalized self-defense for any weapon?
Well, I'm not, I think that Heller quite clearly says, and this is at page at page, this is critical language, at page 592, after Heller has finished its exhaustive textual analysis of the Second Amendment, it says, putting all of these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. So the self-defense piece of the Second Amendment is there. It's there in the Second Amendment, so says Heller. Commonwealth says that's dicta. And it is true that this case
But
involved...
where does that go? I mean, there are a number of things which are barred, nunchucks and other switchblades and other things for which there's no licensing, you're just barred. If you're right, all of those would be permitted.
Let me respond to two statutes that the Commonwealth sort of parades as the slippery slope if my client's conviction is vacated. That is one of them, 10B, 269-10B, the nunchuck statute. That statute does not prohibit the carrying or possession of knives. It makes it difficult, conceitedly, if somebody wanted to make a kung fu movie to do so in Massachusetts, but it does not in any significant way impede an individual's right to carry or possess a knife. Certain types of knives and other strange sounding weapons that were, according to the legislative history discussed in one of the amicus briefs, part of the sort of Bruce Lee fears of the 70s, makes it unlawful to possess nunchucks and so forth. But I would say this, if we had a statute, which we do not, that criminalized the possession of knives, flat, that would run afoul of the Second Amendment. And Heller talks about knives as weapons of self-defense.
There's one thing about guns is that we have the capacity to license guns. And if you're right, wouldn't we have to then expand the licensing to all weapons which are now prohibited? Otherwise,
well, the only other weapon that the Commonwealth points to that is prohibited, in addition to the nunchuck statute, are the assault rifles that are prohibited flatly by 131M. And I think that there are two reasons why a ruling in the defendant's favor, vacating her conviction, does not implicate the permissibility of banning assault weapons. One, and this is discussed in the Aware amicus brief, is that a person in Massachusetts can arm herself for legitimate purposes of self-defense with many weapons that are functionally identical to the proscribed assault rifles. Whereas 131J prohibits an entire class of weapons of legitimate self-defense, and that's the distinction. So, of course, the Commonwealth could regulate the possession of stun guns, but the banning of it is what sort of crystallizes the Second Amendment problem here.
But does that mean, let's assume you win. Does that mean that a felon can possess a stun gun?
I'm sorry?
Let's assume you win today. Would that mean that a felon can possess a stun gun unless and until the legislature acts?
Unless and until, yes, I think that would be the case. But it would be not a simple matter, but the court could easily reverse this conviction while pointing out to the legislature why they went too far. And, so that concern, while legitimate, is far from insurmountable. The other thing I think that's important to keep in mind, and the facts of this case are important, is that this case is different than any other Second Amendment case that has come before this court. The defendant is not suing civilly in order to assert a Second Amendment right that she says trumps the regulatory authority of the state to control weapon possession or use, nor is she defending herself from on a Second Amendment defense to a weapons conviction that involves a weapon that could be lawfully possessed by somebody who was appropriately licensed to do so. My client is innocent of any wrongdoing, but for 131J. She is a diminutive, 4'11", 120 pounds. She was beaten by her ex-boyfriend.
But I hear that. But let's assume she was 6'6", 260 and was the boyfriend. Would it be a different case?
Well, it would be different. I think the facts are relevant because they graphically illustrate how absurd the result here is. And if that result is absurd, it suggests that there could be a constitutional problem. No, the infirmity of the statute would apply to someone regardless of their size. But the effect of the statute in this case should not be ignored. She could have shot him if she had a licensed handgun. Would that have been preferable?
I can't recall. Do you need a license for mace as well? Mace and other kinds of sprays?
You did until recently,
right?
Is my understanding, and the briefs discuss that recent amendment. Pepper spray and mace are now obtainable without a regulatory process as restrictive as it had been formerly. But this is what's important about stun guns. They work, and they do not kill. That cannot be said about any other weapon of self-defense.
Kill is used in the definition of the crime, though. I mean, right?
That's right. But as a factual matter, the use of stun guns have almost never resulted in death, whereas 20%, according to Amici, of intentional use of lawful handguns in confrontation result in death. So the logic of banning, criminalizing a stun gun, a non-lethal weapon, that in this case, and here the facts are also striking, she was homeless as a result of her abuser's behavior in part. She succeeds in getting a lousy job, which she's walking to, and where he continually harasses her.
I take it that's why the case was placed on file, because it was so sympathetic.
I think that's correct.
To be so.
That's correct.
So if now she can have mace or pepper spray or some other legal way.
Well, she wants her stun gun, and she has a right to her stun gun under our theory of the case, and she also has a right not to have a conviction that will follow her for life for doing what any reasonable person would have done. She did not use the stun gun, she displayed it.
Let's assume the facts were different. Let's assume this was the boyfriend who had a stun gun and was using it to torture her without leaving marks.
That would be a crime.
What would be the crime?
Be the crime, not the possession, according to you. It would be
torture, I believe.
No, but let's assume he had it for that purpose, but had not used it for that purpose.
Right. He would be committing a crime of assault and battery or torture.
So is it your view that it's only not a crime if it is somebody who is using it for a good purpose as opposed to somebody who may not be using it for so good a purpose?
I am saying that it is protected by the Second Amendment if it is being possessed for the lawful purpose of self-defense in case of confrontation. And those are the facts of this case.
So the Second Amendment application depends totally on the facts?
No. The reasonableness of a statute that takes weapons out of the hands of the people, it depends on whether the weapon is dangerous in the sense that it should not be permitted to be owned by anyone, or whether it is a legitimate, portable, non-lethal device that in this case disarmed or defused, no pun intended, the situation, and her abuser walked away. So it's a facial challenge, but the facts illustrate the absurdity of what we've done in light of the right that Heller recognizes.
But Heller recognizes a right to have the quintessential weapon of self-defense, a handgun, in one's house.
That is the narrowest holding permissible, but the language that I just read, a weapon, weapons...
But you have to get to your larger language in order to get where you're going, right?
Yes, but the briefs make it clear that this is not a stretch. The Second Amendment doesn't say handguns, it says arms. Heller says that arms are what we think of them. They are weapons to be carried for legitimate purposes of self-defense in case of confrontation, like a stun gun. So although Heller did not deal with stun guns, the Commonwealth's essentially entire argument, which is do nothing until the Supreme Court passes on a stun gun case involving a homeless woman who is outside of her non-home, is frankly not appropriate. She has a right to her vindication of her Second Amendment rights. Those rights are clearly implicated by this statute, and her conviction is unjust. They chose to prosecute her. God knows why, but they did. And so this court has a duty, I would submit, to say whether the logic of Heller, as applied to these facts and this way overbroad statute, compels that her conviction be vacated. I'm over time.
Yeah, actually, one more question, unless others do. What does the record say about her being homeless as to whether or not she had a place to live, albeit perhaps a hotel room?
So the record says that she was, two things. It says that she was living in a shelter at the time of these events, both at the time that she used the stun gun displayed the stun gun to keep her abuser at bay, and at the time she was arrested. She testified that she was living day by day in a hotel at the time that he confronted her outside of her workplace. And the Commonwealth suggests that this discrepancy means she wasn't telling the truth, or we shouldn't trust her story. And I've addressed that in the reply brief, why that argument is not only unfounded, but at this stage of the game, quite unfair, where the prosecutor urged the court to believe her testimony and elected not to cross-examine her. And despite the Commonwealth's argument, you could be homeless and be living in a hotel.
But if you're living, I mean, we've previously said that one's home can be a shelter or the room in a shelter with regard to Fourth Amendment rights.
I don't disagree.
Why would that not be treated? It's assuming that they have a right to bear arms in the home. Why would that not be treated as their home here?
Well, because it wasn't her home as a Second Amendment matter. More properly, even if she had been in a palace in Wellesley, she would have been a criminal for possessing this stun gun. So it is irrelevant.
Because it was in her car?
It was in her purse.
It was in her purse, and wasn't she in a car?
She was in a car and was being, which was being investigated for unrelated shoplifting. She consented to the search of her pocketbook, which was large, and the stun gun,
right,
where she always kept it.
So it was outside of any home, even if she had a home?
Correct. It was in a supermarket parking lot, which the Commonwealth also says takes her outside of the Second Amendment because Heller didn't say anything about supermarket parking lots.
Okay, thank you.
Good morning. My name is Michael Caneb. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. I think there are two ways that this court can affirm the conviction without engaging in the Second Amendment questions that the defendant's attempting to force on the court. And the first is to decline to review it on procedural grounds, which we've both addressed. The Commonwealth's position is that there's no judgment here to appeal under the case law, and specifically under Commonwealth versus Ford. Here, the defendant explicitly consented at trial to the filing, and then, and I stand by this, later manufactured an objection more than 2 months later.
But what difference does it make? Can't she withdraw her consent?
She can withdraw her consent, and in fact, if you look at the paper that was filed, the paper asked to be sentenced, which is what the rule provides. There's a minimum statutory sentence. When the Commonwealth suggested that that be applied, the defendant instead said, well, actually, maybe you can just place it on file for another 6 months and allow me to object. So that I think when the defendant was in effect at the hearing given exactly what she was requesting, it's somewhat disingenuous to object to your own request.
What's your second reason?
Well, the second reason is really the much larger reason. I mean, that is a procedural reason, and the court will obviously consider that. The real reason is that the case is either outside the Second Amendment or it is so minimally impacts the Second Amendment. There's either no burden at all, or the burden is too minor to require justification if the right is in fact broader than what this court has said it is in Commonwealth versus Gauss. Essentially what we know from Heller and McDonald, which both interestingly were selected under identical conditions, is that, as this court said in Gauss, there are two conditions that need to operate for the Second Amendment to apply. I think of it like a Venn diagram, right? That they're overlapping conditions. It involves self-defense of the home and involves an operable handgun. The failure of either condition either places the case simply outside the Second Amendment protection, or it places it so far at a remove that it doesn't require, outside the core right, essentially, was what the federal circuits have said.
There is something that's, I mean, this is Mr. Keene's point, but there's something that's disturbing about protecting the right, one can look at it, protecting the right to a handgun versus protecting the right to have something that's much less lethal.
I agree. I mean, that is a logical question that the court would need to raise, but I think it does bring you back to what's the logic of privileged treatment for guns in Heller.
I've never understood it, but you can go ahead.
Heller simply says there are certain policy judgments off the table, and that's guns. I think we can look at the other things that are special about...
Is Heller really so limited only to guns?
Pardon me?
Is Heller really so limited to handguns just because the facts of it involved that?
Well, I think that question, and the defendant's whole argument essentially, it raises, that question or that assumption needs some inspection because it does assume a generalized right? Well, that has certain consequences. One of them is precisely what I'm saying, which is that you've now expanded to an entire universe of weapons. So that if you have every other weapon available to you, most importantly, what I think we can at least agree is the core right, which is a firearm. If you have a firearm available to you, if you have a billy club, a nightstick, expandable wands, if you have any knife not banned by Section 10B, if you have mace, pepper spray, other objects, if you have the entire universe of other instruments available to you for self-defense.
A shod foot.
Pardon me?
A shod foot.
A shod foot. Is it really a substantial burden, or is it only incremental contact to ban one kind of weapon that's rarely used, that's possessed by less than 1% of the population? It's like preventing access, perhaps, to one model of a handgun. But if you compare that, and these figures are in the brief, if you compare that to what Heller clearly says is the core right, which is a firearm, well, handguns, there are 114 million or more handguns privately possessed in the United States. The defendant's own assertions at the hearing on this and the documents indicate quite clearly that there's less than 1 million stun guns. So to make
But
one...
if there were a sale at Walmart for stun guns and everybody bought it this Christmas season, I doubt your argument would change. Is it the sheer number?
Oh, I think it's really about the universe of weapons that are available. That and I go back to sort of a number of the federal cases rely on First Amendment analogies. In the First Amendment, where there are ample alternative channels of communication, or I would say here, ample alternative channels of self-defense, it is not a substantial burdening. It's not even a measurable burdening. And I would direct the court to De Castro, which is a Second Circuit decision, and Heller too also makes this point that, for instance, prohibiting somebody from possessing a firearm without a serial number on it, that simply doesn't impact the Second Amendment, because you can still possess the entire universe of handguns that are out there that do have serial numbers on them. So one has to look at how severely the right, however it's defined, is being burdened before one knows what level of scrutiny to apply to it.
Can I ask you on that question? There's an amicus from a women's group.
Yes.
And is there any indication that stun guns are used more by one gender than another?
I don't have that information. I have read a lot of the academic articles about stun guns.
Or that women are more likely to use non-lethal types of weapons in self-defense?
I'm not aware of anything like that, but it does sort of bring up the question of that I think defense counsel is resting on, which is this notion that a stun gun is inherently defensive. Well, what is defensive? And I would suggest that that's a very difficult analysis. Handguns, to me, don't seem defensive at all, and yet they are the quintessential instrument for self-defense, according to the Supreme Court. I would suggest these are what some of the federal courts have said, sensitive policy judgments, distinctions among weapons. What's good for defensive with stun guns is also good for offensive. They're small, they're easily handled, they're easily concealed. They may be non-lethal, but they do cause incapacitation.
And pain.
And intense pain. They're able to be used for repeated indiscriminate use. They're very good instruments for torture or compulsion. So I don't know that, particularly a court, sitting where a court is, you're making a constitutional judgment. Things are all on or they're all off.
Is there...
I'm sorry, go ahead.
I don't know that it's possible to draw those fine distinctions.
I just wonder, is there legislative history about the rationale for banning them?
I know some of the federal history, that initially they were banned by the appropriate federal agency because they were originally designed as tasers, and they used a gunpowder charge to discharge the wires that got sent out. That was removed in the mid-90s, I gather, when the taser technology changed, so that they're now ejected with something else. I don't know about stun guns themselves.
But the arguments that you make could also apply to things like knives, which can be used to torture people. That's correct, yes. Cause great pain. Would that make sense then to just say all knives should be banned that have, I mean, it's an entire category that is being banned.
Well, yeah, I guess. I mean, it's an entire category that constitutes less than 1%. I don't know. I mean, it's kind of a taxonomy of categories. It's a non-lethal form of defense. I mean, if the Second Amendment, it kind of depends on what you think the right is, Your Honor, I guess. That if the Second Amendment protects stun guns specifically, then it's a very severe restriction, and it's equivalent to the D.C. restriction in Heller. If the Second Amendment only protects, in a general sense, weapons of self-defense, then to single out one particular item, like an assault weapon or a weapon that's had its serial number removed, is not a meaningful burden. It doesn't significantly contact the right. If you think the right is even more specifically a right to possess a handgun in the home, then of course there's no contact whatsoever. And I would just point the court's direction to the, there have surprisingly not been more cases like this. There's obviously the stun gun case that the defense has relied on. I have them cited in my brief, but the District of Columbia Court of Appeals has said that ice picks and knives, even when carried for defensive purposes, are simply not covered by the Second Amendment. There is a federal case in the Southern District of West Virginia that concludes that body armor, although it falls within the definition of arms taken from Samuel Johnson's dictionary, which is cited by the defense, although it would qualify there, it doesn't qualify.
Are there statutes banning those things?
Yes, I think in each of those cases there were.
There are statutes banning body armor?
I think in that case there was a statute banning body armor. I think the defendant in that case might have been a convicted felon.
And there are statutes that ban ice picks?
I can't remember I think it would probably be similar to the 10B list that was being carried, and it was the other case was a knife. But those cases are both cited in the brief, Your Honor. I would also just briefly like to address the place of the home. It's clear that Heller says that the need for self-defense is most acute in the home. And so that contradicts the view adopted by at least the Seventh Circuit and urged on the court by the defendant that when one goes outside one home, the need is greater.
What would you do if the woman lived in the car?
I think that would present a more difficult circumstance, Your Honor. I think the problem is, certainly, and I did not contradict the fact that the woman was homeless, and I certainly understand the fact that living in a shelter or a hotel still leaves someone homeless. The only point drawn in the Commonwealth's brief was precisely the point drawn by Chief Justice Gantz, which is that hotels and motels have been sufficient constitutional protection for other rights. I do think that a defendant literally with no place would present a problem. I don't think that the solution to that...
Why would it present, you mean it present a problem if the Second Amendment...
If the Second Amendment, in fact, operates outside the home, and if the Second Amendment, then I think the court would be forced with that. This court has said, in Gauss, that it doesn't operate outside the home, and that was a case much closer to Heller. That was actually a firearm case. I don't know that the court, again, I don't think the court needs to go so far as reconsidering Gauss, where there's other means available for the defendant to protect herself with weapons, where the core right is untouched, where there's no implication that the core right of possession of a firearm is touched here. There is a logic to the home. I think it is already a recognized limit of governmental limitation like other rights. First Amendment, possession of obscenity, a Second Amendment. As I've pointed out in the brief, there is a history of permissive regulations to prohibit carrying of weapons outside the home. Third Amendment, quartering troops in the home. Fourth Amendment, search and seizure. It's clear that the home is treated differently than the public realm across a broad range of rights. There's also a sort of logic to it, that if one needs to seize a weapon within one's home, perhaps the logic of the Supreme Court is that it is more likely that there is an intruder, that there are defensive purposes at work. And once you're outside the home, the likelihood of an offensive use is perhaps enhanced.
Could one possess a stun gun in one's home legally?
Not under the statute, Your Honor. It's not presented by this case, obviously.
I understand that, but I'm just saying.
But no, it's an absolute ban on...
It's an absolute ban in all locations.
That is correct, yes.
Yeah.
May I ask you, please, about the point that Mr. Keene raised, suggesting that the Commonwealth says that we should do nothing but wait until the Supreme Court gives further guidance on this. I know there were some cases cited in your brief, but is that the position that the Commonwealth takes, that the issue should be unresolved unless the Supreme Court has given more guidance on what the core of the Second Amendment means? Does it extend just to firearms, and is it just the home? What's your position on that?
Well, I think only two federal courts have outright said that the right extends outside the home. So that's the Seventh and the Ninth Circuit. I'd say the majority of the federal courts have taken the position that it's a very complex question. Heller is a very complicated decision. It's not fully internally consistent, and there are very high stakes involved. So perhaps, if they can, the best solution is to say, assuming without deciding. I think that's what most of the cases say. Assuming without deciding that it extends, the first thing they say is it clearly doesn't extend with the same power that it would within the House. And second, then they measure the level of impact. My point here would be, we're not within the home, so assuming without deciding, it's a reduced Second Amendment.
Right.
And it's further reduced by the fact that we're dealing with something that wasn't an issue at Heller, that doesn't have the historical pedigree, that doesn't even have the connection to the prefatory clause of militia service, so that it would be fairly easy for the court to say, assuming without deciding it applies outside the home.
Well, we don't own the Second Amendment in the way we own the Declaration of Rights, so we don't have this sort of proprietary control over what it means in the way.
I think the defense counsel in his reply brief has suggested that I've argued that the court can't decide this. That's not my suggestion. Of course, the court can, but there are prudential reasons why other courts have said, assuming without deciding it applies in this circumstance, we think it would survive the appropriate reduced level of scrutiny. So,
Thank you.
Thank you very much.